Hello, and welcome to Doomed to Repeat It. I'm your host, Brett Thomas. We're going to start with some stories from history before we get to our current event. The connections may or may not be obvious, but I'm now going to start by giving you a 50,000-foot overview of the English Civil War. This formally ran from 1642 until 1651, though the events that led up to it really began in 1625 when Charles I ascended the English throne in his mid 20s. Back in those days, Parliament was not a standing body. They were more like a set of advisors the monarch could summon when need arose. The main thing that the monarch needed from Parliament was permission to raise taxes. In no small part, this was because of the feudal system. Peasants worked land owned by lords, with a hierarchy of lords leading up to the monarch. Those lords, who also made up Parliament, were also effectively the king's tax collectors. But from their perspective, the taxes they didn't send to the royal coffers they got to keep for themselves, so they had to be convinced to send the crown more money if it was needed. Over the hundreds of years since the Magna Carta was signed in 1215, Parliament's power had continued to slowly grow as they tried to exert more control over the monarch. King Charles greatly resented it. He felt that he ruled by divine right straight from the authority of God and greatly wished to be able to do whatever he wanted to. Things did not start off well. In the first years of his reign, King Charles married French princess Henrietta Maria, who was Roman Catholic. Obviously, Parliament would have preferred an Anglican, someone who belonged to the Church of England. Traditionally, Parliament would formally grant a new liege the ability to collect customs duties, what we'd call tariffs today, for their whole reign. After Charles married Henrietta, though, they decided that instead they would only grant this to him on an annual basis, forcing a yearly negotiation between the king and Parliament. Charles responded by ignoring them and simply continuing to collect the money without Parliament's permission. After all, he didn't need their permission since he ultimately had authority from God. Without getting into the messy details, things went rapidly downhill from there in Crown Parliament relations. The Parliament of 1628 had a contentious relationship with Charles, and he summarily imprisoned without charge or trial several members of the opposition. John Eliot died while imprisoned and was considered a martyr to Parliament by those who opposed Charles. Thus began the personal rule of King Charles. He did not call Parliament again for a decade and a year, the longest period that Parliament had not been called in over 400 years, ever since it began meeting regularly in the 1300s. Of course, the royal opponents did not call it this. They knew it as the 11 Years' Tyranny. During the time, Charles's policies were mostly driven by his lack of money. Quickly, he removed England from the expensive 30 Years' War. Then he tried various creative ways of trying to raise taxes without Parliament, with varying but little success. Charles began using the power of the crown to put the screws, often literally, to the opposition. His preferred tool was the Star Chamber. This judicial council was originally established in the late 15th century as a high court for powerful nobles too influential to be fairly judged in an ordinary court. Over time, though, it became a tool for the monarchy to enforce their will on their opponents. The Star Chamber in King Charles's hands became his own personal judge, jury, torturer, and executioner. As I go through each of the following, I want you to remember the explicit guarantees to things like a jury trial that the U.S. Constitution provides. His opponents were often held indefinitely without charge. Judicial proceedings were secret, so there was no ability for the public to observe them. There was no jury. Defendants had no right to a lawyer. They were often tortured in order to confess their supposed crimes, in other words, to incriminate themselves. Finally, the punishments themselves were often gruesome. William Prynne, a Puritan lawyer who wrote a book criticizing court life, was branded on his cheeks with the letters SL for seditious libeler, had his ears chopped off, and was put in a pillory for hours. Finally, in 1640, there was a rebellion in Scotland, which had only recently begun union with England in 1603 under Charles's father's reign, when James VI was the first monarch to be king of both countries. Technically, this was not full unification yet. It just so happened that he was the king of both countries, but they had their own fully separate political systems, similar to the way that King Charles III is both the king of England and the king of Canada, and yet those are two separate countries with separate political systems. This put Charles I in a difficult spot. He needed a lot of money now to put down the rebellion in the other country he ruled, but there wasn't any particular reason why anyone in England should care about it. He had no choice but to finally convene Parliament. Unfortunately, this did not go well. Parliament attempted to use Charles's need for tax money to provide a list of grievances with his rule. The offended monarch instead dissolved it after only 3 weeks. This is known to history as the Short Parliament. Without the support of Parliament, Charles raised what military he could and invaded Scotland to put the rebellion down. This was a disaster. The English army was chased from the field, and Scotland counter-invaded northern England. Charles, unable to raise the money needed to chase the Scots from the country, ended up paying protection money to the Scottish army in the north of England to keep them from rampaging and pillaging all of the north of the country. Charles was absolutely in an untenable position, and he knew it. The only solution was money, and the only place to get money was in Parliament. In November of 1640, he again summoned Parliament. This one is known as the Long Parliament. It immediately was even more antagonistic to Charles than the previous ones had been. One of their first acts was to pass a law saying the new Parliament would meet at least once every 3 years, whether called or not. They also gave themselves the ability to dismiss the king's ministers. Finally, they said that the king did not have the power to dismiss them without their consent, even if their 3 years were up. Parliament was increasingly considering itself to be the crown's partner in governing, not unlike how, in the US system, absolute power is vested in neither the president nor Congress. They formally abolished the Star Chamber. Further, they passed the Habeas Corpus Act. This gave English judges the ability to present a writ of habeas corpus to a jailer whenever someone had been imprisoned. Latin for "you should have the body," it compelled the jailer to bring the defendant before a judge and justify what they were charged with. Should the justification be considered insufficient, the judge could simply release the prisoner right there. However, it wasn't all goodness and light. Parliament attempted to impeach Charles's ministers, and when they were unable to do so, they attempted to simply pass a law declaring them guilty and imposing a penalty. An obviously unjust process called a Bill of Attainder. The English Civil War was literally war between the king and Parliament. Each raised rival armies. There is much more to it. It went on until 1651. Lots of people, including King Charles I, got their heads cut off. But I think we now have the context we need for our next story. The last major battle in the American Revolution was the Siege of Yorktown in 1781, at which the British General Cornwallis surrendered to General Washington. If you see the musical Hamilton, it's the scene immediately prior to intermission. But winning the war was one thing, the American victors also needed to establish a government. As Washington says in Lin-Manuel Miranda's musical, winning was easy, governing is harder. One early decision they made was to actually formally write down the U.S. Constitution. The English Constitution was not formally documented in a single place. It was simply the basis of centuries of judicial opinions. One of the most significant contributors to the Constitutional Convention that authored it was James Madison. In his mid-30s at the time, he was a Virginia planter turned political theorist whose deep study of history, philosophy, and law later earned him the title Father of the Constitution. He was educated at the College of New Jersey, now Princeton, and I do feel a need to note that, as a Virginia plantation owner, he also enslaved many people. In the gap between the war and the Constitutional Convention in 1787, Madison did all the research he possibly could. He wrote his friend Thomas Jefferson, representing America in France at the time, to mail him any history books that he could find in Paris or London about the history of previous democracies and the theories of government. The letter found Jefferson temporarily in London, and he was happy to help. In his May 25, 1784 letter, Jefferson replied, "Address yourself to me as your bookseller for London or Paris, because at whichever I shall be, I can easily order books be sent to you from the other. In the letter of March 16, you wish for any good books on the public law or constitution of several existing confederacies, and on the law of nature and nations. There are some books of Boynon's in the first of these subjects, but I have not time to examine them. I can do this so conveniently in Paris, get them on so much better terms, have them bound, and send them so speedily, that I will defer the execution of this commission till I get there." The ever-in-debt Jefferson later sought recompense for the books from Madison in a letter, and was reminded that he owed the latter money, to which he sheepishly replied, "In that letter I sent you a detail of the cost of your books, and desire you to keep the amount in your hands, as if I had forgot that a part of it was in fact your own, as being a balance of what I had remained in your debt." Jefferson had come through, though, sending dozens of books to Madison over the coming months. Madison read about Montesquieu's checks and balances concepts from his 1748 The Spirits of the Laws. He probably read histories of the English Civil War. His family had first migrated to the U.S. in the 1650s in the wake of it. Remember that in 1787, the English Civil War was only slightly more recent to them than the U.S. Civil War is for us in 2025. Certainly, any educated person would know the details of it. Beyond researching the latest thought on the constitution of government from Enlightenment thinkers, one concern at the front of Madison's mind was the fact that every democracy or republic prior to that date had eventually failed and had fallen into despotism. He studied especially how these states had failed and felt he found a common thread through them. A populist figure, a demagogue in Madison's phrasing, would sweep to power and overwhelm the unwritten constitution, making themselves dictator for life. Julius Caesar's murder of the Roman Republic was a prominent example, but Athens under Cleon and collapse of the Dutch Republic in the 17th century, he felt followed the same pattern. With all this research, Madison felt he had two big goals in authoring the U.S. Constitution. Number one, a system that would avoid another Charles I. Number two, a government that was immune to Caesars. I'm sure we will talk about his efforts to avoid demagogues at a future time. For now, though, I want to talk about the things he built to prevent a government like the one England had under Charles I's decade of tyranny. This begins in the body of the main document itself, in Article 1, Section 9. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder or ex post facto law shall be passed. Ex post facto is Latin for after the fact, and it means making things retroactively illegal. While Madison doesn't go into much detail on the writ of habeas corpus, the fact that it can't be suspended under normal circumstances established that it exists in America and must be respected. That's all there is in the body of the main document. Madison initially wanted not to include a list of all the things that the government can't do in the Constitution because he worried that it would come to be taken as a list of the only things the government can't do, something that indeed it largely has been. However, to get the Constitution approved by the states, he agreed to later draft a Bill of Rights explicitly enumerating the things the government is not allowed to do, a rather unique concept in a government's founding document for the time. After grudgingly agreeing to author the Bill of Rights, Madison became its biggest champion. And if you look at the abuses of King Charles I detailed earlier in the lead up to the Civil War, it's practically a checklist. His opponents were often held indefinitely without charge becomes the Fifth Amendment's no person shall be deprived of life, liberty, or property without due process of law. Judicial proceedings were secret inspires the Sixth Amendment's guarantee of a speedy and public trial. Of course, this also bars indefinite detention without charge. There was no jury, leads the Sixth Amendment to also note that in all criminal prosecutions, the accused shall enjoy the right to trial by jury. The Sixth again answers defendants had no right to a lawyer, with in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The Fifth Amendment covers being forced to confess, noting that no one may be compelled in any criminal case to be a witness against himself. And finally, torture and horrific treatment are barred by the Eighth Amendment, which outlaws cruel and unusual punishments. If you've ever wondered what a writ of habeas corpus is, or why the system works the way it does, this is the history of it. Madison and the other founders were trying to prevent a despotic government treating people unjustly, and these are the mechanisms that they implemented to prevent it. Perhaps now that I've laid it out this explicitly, you'll know what our current event is this week. I'm not going to get into the finest details of the individual case I'm about to give you. They have been documented in great detail elsewhere if you're interested, and the beginnings of this case in the news are already more than a month old. But on March 12, 2025, ICE picked up Kilmar Abrego Garcia in a traffic stop in Maryland. With no hearings from a judge, they told him his legal residency had been revoked due to a 6-year-old unsubstantiated allegation that he was a member of the gang MS-13. On March 15th, he was on a plane to prison in El Salvador. On March 24th, lawyers working with his wife finally filed a case requesting habeas corpus. However, Garcia was long out of the physical custody of the U.S. government, and the government argued that the courts had no right or ability to enforce habeas corpus on Garcia, even though a court in 2019 had explicitly barred his removal to El Salvador in particular. Much of the ensuing public debate has centered on the question of whether or not Garcia is a member of MS-13. I will not address that because it absolutely does not matter to the real problems we have here. The government could allege that he's the leader of MS-13, and it would not affect the crisis to 250 years of liberty that this represents. Aside from this particular case, we also have literally hundreds of other cases in similar time span in which an alleged immigrant, here legally or not, has been picked up. The way habeas corpus works in the modern day requires that it be filed in the legal jurisdiction where the person is being held, so that the jailer and prisoner do not have to travel far to the judge. The government in these cases, immediately after detaining people, cross them over the nearest state line so that when the family files a writ of habeas corpus where the arrest happened, they can argue it should be denied because the prisoner is no longer in the jurisdiction they were arrested in. Next, they immediately are moved 1,000 or more miles to a third jurisdiction. Partly, this is to make filing writs of habeas corpus more difficult, but also because they choose this jurisdiction because they believe the judges in it are more likely to deny the writ or to find the government's justification for holding them to be sufficient, no matter how thin or contrived. Finally, within 72 hours of being detained, the victim is on a plane to El Salvador, now, by their argument, out of the range of the protections of the United States courts. For the vast majority of the past 250 years, people in the United States have had protection from being held without being charged with a crime by the U.S. Constitution's guarantee of the right of habeas corpus. And we've been protected by the Sixth Amendment's guarantee of a speedy public trial. We've had two major exceptions inside the boundaries of the U.S. in that time. First, President Abraham Lincoln suspended the writ of habeas corpus during the U.S. Civil War, certainly a time of revolution when the Constitution grants the president the power to do so. Historians agree that he was judicious in using this, however. Much more shamefully, the U.S. government simply ignored it while interring Japanese Americans during World War II. And assuredly, up until the Civil Rights Act of 1964, there were various local abuses. Other than that, we have largely learned the lessons of the English Civil War 375 years ago and worked to avoid these excesses again. Now, President Trump claims that he can pick a person up off the streets, move them around rapidly to frustrate judicial notice and habeas corpus, and finally export them to a foreign concentration camp for life with no possibility of parole. All without a trial and immune from review after the fact. Defenders of President Trump will shrug this off. He's a member of MS-13. He did terrible things. He doesn't deserve a trial. The fundamental problem with this, of course, is the reason we have trials is to determine if someone is guilty. If the government's argument stands, and they have figured out a way to disappear people in a way that, if not technically legal, can't be barred by the courts, then there is no check on them doing this to anyone they want, by mistake, or simply because they disagree with the person. Even if you support President Trump and think he is using this power wisely, I want you to imagine a future President Harris being able to disappear anyone she wants. These protections are there to protect all of us, no matter who is abusing their power, and effectively ending the protection of habeas corpus cannot have a good long-term effects on our republic. These cases are moving quickly, but at recording time, Mr. Garcia is still being held in El Salvador, while the Trump administration continues to insist that they have no ability to retrieve him, despite a 9-0 Supreme Court ruling instructing him to do so. Finally, I would like to tie all of this together with another story from history. When the Nazi Party rose to power in the early 1930s in Germany, their obsession with the Jews came with them. Adolf Hitler was convinced of an incoherent set of conspiracy theories and thought that the world economy was secretly controlled by both the capitalistic Jews and the communistic Bolsheviks. He and other conspiracy theorists believed that Jews did not make functional citizens of European countries because their true loyalty was to the Jewish world conspiracy. Consequently, he intended to counter this threat by removing all the Jews from Germany and ultimately Europe. He initially did not set out to exterminate them. Historians debate if it was always his intention to exterminate them later, or if his goals changed while in power, but he started with a few initiatives. One was to make life difficult for German Jews. He encouraged violence from his followers against individual Jews. Among other crimes, he seized the money and property of wealthier Jews. They were barred from civil service jobs, even if they already had them. Beyond his desire to use their money to fund the German state, he hoped he could make life for them so miserable that they would simply leave, to self-deport in the recent phrasing of the Trump administration. Then, in 1935, with the Nuremberg Law, they officially made the Jews not full German citizens. Only those of German or related blood would be citizens. Jews were now subjects of the state, not citizens of it with its protection. Later, their passports were revoked and confiscated. In addition to the increasing pressure to self-deport, many were summarily deported, rounded up, and sent to arbitrary second countries. Even Jews who were native to Germany faced this fate, even those who had fought loyally in World War I. In addition to the direct goal of getting Jews out of Germany, Hitler hoped to create evidence for the myth he'd invented. He wished to cause a flood of passport-stripped stateless Jews in all the countries of Europe, thus proving that the rootless cosmopolitan Jews, in Nazi language, had loyalty to and were true members of no European country. A big part of the lies of totalitarianism is to manufacture evidence for them, however scant. Of course, we now know the ultimate fate of those who weren't deported, voluntarily or otherwise. In many ways, those kicked out were the lucky ones. This highlighted the problem that so-called stateless people have. Unfortunately, that term quickly went out of fashion after World War II. Here's Hannah Arendt from The Origins of Totalitarianism. Even the terminology applied to the stateless has deteriorated. The term stateless has at least acknowledged the fact that these persons have lost the protection of their government and required international agreements for safeguarding their legal status. The post-war term displaced persons was invented during the war for the express purpose of liquidating statelessness once and for all by ignoring its existence. In the modern world, the stateless person has no home that will let them live there legally. They've fled from or been removed from their native country. They now reside in another country that does not recognize their presence, and they do not have a passport to travel legally to another country, should one even allow them to do so. Even leaving aside the serious liberty concerns about how the denizens of the El Salvadoran prison CICOT came to get there, they are now stateless, residing in a state that offers them no legal protection. Even were they to escape or be released, they have no passport and no country that necessarily recognizes their right to live there. All of modern world civil rights are predicated on the individual being under the protection of the state. The UN Declaration of Universal Human Rights is aspirational. For enforcement, you need a functioning government at your back. In addition to the illegality of these people's imprisonment to begin with, they now face the prospect of being forever bereft of a home. In this episode, we learned about Charles I's excesses in the English Civil War. Next, we reviewed Madison's efforts to create a form of government that would constrain its leaders to ensure that the evils such as those created by Charles I would not be able to happen here. Our last story reminds us that using deportation as a weapon against even natural born citizens of a country is not a new idea. Tying them all together is today's tragic story of Kilmar Abrego Garcia and hundreds of other immigrants who the Trump administration has thus far successfully prevented from exercising their right to petition for habeas corpus. When you think about the government abuses that these constitutional protections were designed to protect us from, it is rather distressing and depressing that apparently so many of our leaders and fellow country people either do not know or do not care about why these rules exist. President Trump is today trying to deprive immigrants of their right to habeas corpus, but he has already publicly stated he wishes to do the same for citizens. If you felt it was useful to learn these stories, I'd appreciate it if you would like and subscribe, and I'm always interested in hearing questions or corrections in the comments section. Given how all the stories I told you today are very clearly people making mistakes in history and us trying and failing to build mechanisms to avoid making them again, I have to feel this week that we are very much doomed to repeat it.